Welcome to another episode of Kidon, War Stories from the Cutting Edge of IP Monetization. My name is David L. Cohen. I'm the owner of Kidon IP, a consultancy, and David L. Cohen PC, a law firm, where we provide IP monetization services to clients both large and small. Every episode, I interview other subject matter experts and leaders in the wide world of prosecuting, asserting, analyzing, monetizing, and defending intellectual property rights. You can find this show on YouTube, LinkedIn, Apple Podcast, Google Podcast, Stitcher, Spotify, and many more. Today, my guest is Otto Licks. I first met Otto while at Vringo when I was developing a global monetization campaign in which he and his firm played a huge part. He is the founding member of Licks Attorneys, a Brazilian law firm with over 300 professionals, with its offices in different cities in Brazil and in Tokyo. He has been doing complex litigation and IP policy work for well over 25 years, representing many international and well-known clients. He started his career working in IP policy at the Organization of American States in Washington and at the UN as a consultant for the Brazilian State Department during the implementation of the WTO agreements by the Brazilian government. So he's very well connected. He joined private practice to start a career as patent litigator with CCITT, switching and signaling, and he was responsible for the first Brazilian nationwide adjudication campaign for patent monetization. Otto has established, and I can vouch for this, a reputation as a trial and appellate practice attorney with an outstanding track record. Maybe we'll be talking about some of his successes in obtaining, defending, and enforcing preliminary and permanent injunctions. Licks Attorneys and Otto's firm represents all various different SCP owners in Brazil, Brazilian litigation, and has a well over 80% success rate in PIs in 14 different adjudication campaigns. Most importantly, from my perspective, Otto is a straight shooter who gets stuff done quickly and is a great conversationalist. And if you're going to be doing a global campaign around the world, he's a wonderful person to hang out with and strategize with. So that's my thing for Otto. So why don't we get started? Pleasure to have you here, Otto.
David, it's a pleasure to be here with you. It is awesome to have the opportunity to chat about things we have done and about things that can be done in Brazil and elsewhere.
Excellent. So I know I ran through your CV briefly, but maybe how did you get into the IP world? Did you start off as a technology person, or how did you get into IP?
Yes, I started as a technology person, and when micro mainframe was a big thing, when large banks and companies were starting to interface the VMSs and the big mainframe machines with the small microcomputers, and did a lot of work in database. Ended up interesting having as clients some of the global companies that many years later, as a lawyer, I had the
Right.
pleasure to represent. Just to give an idea, to one of the large Swiss um, pharmaceutical houses, I actually did my first project for them, not as a patent litigator, but doing their very first system to help sales reps visiting physicians and doctors um, with background information and the starting of value added, and maybe it was the grandfather of Salesforce and softwares like that.
Oh,
So
that's really fascinating. So,
that,
so for our listeners out there, Otto, is it common? I know, like in some countries in Europe, it's not common for lawyers in the patent space to have a technical background. Is that common in Brazil, or is that
no, it is not.
right?
No, it is not. Law in Brazil, as in basically all Portuguese and Spanish speaking countries in Latin America, follow the continental European system where law is an undergrad program that takes 5 years.
So that's one of the unsung advantages, I think, of your firm, is that the people understand what they're litigating and they're dealing with, which is
And we're very proud of that. Yes, yes,
excellent,
yeah.
excellent. So there's a lot to talk about, but maybe we can start off with some teasers. What are the current hot issues going on in Brazil in the realm of IP?
Well, I think the number one issue right now, it is the term of the Brazilian patents. Different from the U.S. Supreme Court, the Brazilian Supreme Court doesn't actually have an interest in patent law that much. And they have just decided the first case after 25 years of our patent statute. And they did that, unfortunately, to kill a provision in the statute that allowed a patent to have a term of 10 years from the grant, in addition to the term of 20 from filing.
Right.
The Supreme Court basically said it's a very long opinion. It's the case with the largest number of amicus ever at the
Right.
Supreme Court. And to summarize, very long opinion, they say that a patent term adjustment needs to take into consideration the specific delay of every and each application, and not have a single rule granting 10 years from grant,
So
which is
for
basically,
sorry to interrupt you, Otto. For our listeners, why was it such a big deal? And I think I know the answer, but maybe if you bring
well,
it out, why was it
the,
such a big deal to have this
uh,
extension?
the big deal is that because of the delays in prosecution at the Brazilian PTO, because of the huge long pendency time of the Brazilian PTO, most of the Brazilian patents for over a decade were actually granted with the 10 from grant and not the 20 from filing. So it makes all the users of the system uncomfortable, because basically every single issued patent in Brazil would have a term of 10 from grant. The Supreme Court said no, the Brazilian PTO can no longer issue patents for that. So there is a lot of expectation from patent owners to have a much longer patent term,
Right.
were actually frustrated with the sudden change. In
What is
addition,
the what was the average pendency of a patent?
average pendency was between 8 and 12 years, depending on the group art.
Right.
Depending on the group art. Okay. But then it got worse for the pharma people, as a case decided during the pandemic. The healthcare was, of course, very emotional and dear,
Yes.
and the Supreme Court ended up not grandfathering the patents already issued um, in the pharma field. So those patents actually had a patent term cut, and they all were republished by the Brazilian PTO with the 20 from filing and not 10 from grant. So several patents were in fact annulled, because
Right.
once the Brazilian PTO implemented, was no term left.
Right. I
There
could see that could
is
be a problem.
nowadays the executive government works looking into the PTA experience from different countries, including the US, which is a bit different from the rest of the world. Uh, but to see if we can have a bill introduced in Congress to have a new PTA system.
Got it.
That's one.
Are there any other hot issues, Otto?
Yes, we have another hot issue, which is again focusing on pharma, again on, let me say, a uh, side effect of the pandemic, which is a law that was not introduced by the administration. It was introduced by some members of the Brazilian Congress that are not from the president's party, the opposition,
Right.
trying to severely impact the compulsory license system. And some of the provisions in the bill go as far as um, creating an obligation to the patent owner to transfer the data package required to approve the drug before the Food and Drug Agency, which
Wow.
we all know is not subject matter of a patent. Um, and in addition to that, creating an obligation for the patent owner to actually teach the company receiving the compulsory license to um, produce the product that is covered by the patent, which we
Wow.
also understand it's something that we can talk about, but you can hardly ever do because you might have a company that owns a patent on a new molecule and they are a research lab or a small startup and they don't have a single plant and they have no idea how to scale up
Right.
into what it needs to be done to get from a wonderful invention into an actual pharmaceutical drug at
Product.
the
Yeah.
pharmacy. But
Right.
that was the Brazilian government, David, I'm happy to say, had a remarkable technical position trying to um, diminish the political escalation done around this topic during the pandemic. But as you know very well, it is very difficult to talk to people outside the patent community about standard essential patents and also about compulsory license of pharma patents. This bill was approved against the parties that form the coalition supporting the government. The government has vetoed the most outrageous sections of the law, and we are working hardly to make sure that Congress does not overrule the presidential veto.
Wow. Well, good
It
luck.
is,
It
it is,
sounds like it could be a big problem.
it is, yeah, it is now a highly debatable and emotional subject matter. But if we look into the past, having a pandemic every 100 years or so, the um, eventual implementation of this law is something that I won't have to actually be worried about, or none of my colleagues working on this project. If this, for any reason, uh, the presidential veto gets overruled, maybe someone will look into using this law in 100 years or so.
Right.
So this won't be an issue for me any longer.
Is it specifically limited to pandemic situations, or can it be applied in other
It
areas?
is no, it is limited to. It's not limited to the definition of pandemic, but it's limited to other definitions in life science, like national emergency um, and government use. So
Right.
it's not the very same definition,
Got it. Got
but
it.
again, it's not that we didn't have a a compulsory license provision in the law. We had always had the compulsory license
Right.
provision in the law. It's something that is easy to talk about, but it's hardly ever implemented.
Right.
And by the way, without any need for a compulsory license, a Brazilian government-owned pharmaceutical industry was able to obtain a license from AstraZeneca and is manufacturing the API and the vaccine in Brazil.
Hmm.
As another company in Brazil was able to secure a license from another industry as well, and it's also producing in Brazil API and formulation. So we have in the country the example that licensing, negotiations, and talking usually work better and faster than having to use compulsory license or any or other means of trying
Right.
to
To force
implement public
technology
good.
transfer. That's right.
Yes,
Yes.
yes, yeah.
So there's a lot to talk about. It's a wide space in your firm, and you cover a lot of areas. But I guess since most of the people watching are not from Brazil, what should people who care about IP generally, or as a business matter, what should they know if there's like two or three things that they should they know about IP in Brazil and why it's important to sort of keep it in mind in your strategy?
Well, if we look into the tech industry, for instance, uh, I can summarize in a slide a bit of information about Brazil that
Sure, Sarah, can you
you
get the
might not
slide up?
have on top of your head. Well, first of all, Brazil is a big market. It's the fifth smartphone market in the world. Brazil is also a heavy user. Brazil is fourth in internet use, is first in share desktop search traffic for Google, is second in Netflix usage, third in WhatsApp and Instagram, and fourth on Facebook. So Brazil has a population that likes to purchase products and use services. As a jurisdiction, is an NPE-friendly jurisdiction. It makes no difference if you making yourself or if you're licensing. It
Yeah.
makes no difference if you're a small company or if you're a global company. And it's easy to understand why. The Brazilians are the second largest users of the patent system in Brazil, only second to the US. Uh, and most of the Brazilian users, most of the Brazilian companies that own patents, they are small and medium-sized companies. Several of them are non-practicing entities, which makes the everyday business in Brazil and the everyday enforcement in the country friendly to NPEs.
That's really fascinating. I can attest to that for sure. We had some fun time together when I was at Vringo doing that, and I'm sure you have plenty to say. Is so the Brazilian system is like a federal system, like sort of not unlike America, and they're different jurisdictions, if I recall, that are more or less friendly to patent owners. And is
Well,
that something that should be taken into account as you develop your IP strategy?
Uh, yes. Uh, the Brazilian legal system is organized. Um, it's not equal, but we can draw some comparisons to the U.S. legal system. And unfortunately, the use of the same sometimes the same terms get a bit confusing.
Yes.
Brazil has a federal court system, just like the U.S. But different from the US, our federal court system, it has in fact the jurisdiction that you see at the US Court of Claims. So if you're not suing the government, you're not in federal courts. So you have to understand federal courts, the defendant will be always the government, a government agency, um, but never private parties adjudicating a dispute.
Right.
That goes to what we call state court system. Well, I understand the US has state court systems and that depending on the states, they vary a lot. In Brazil, despite being called state court system and actually having the judges being sworn by the state and not by the federal government, um, the state courts basically only apply federal law. That's certainly true for patent and the adjudication of disputes. Brazil has codes like you find in Germany, Italy,
Right.
and France. And those codes are applied by the different states, uh, we hope, in the same manner. When that doesn't happen, we have two courts in Brazil with nationwide jurisdiction, one being the Supreme Court, the other one we could compare to the CAFC, that will try to harmonize the implementation of the law among the states. So, despite being state courts, we have um, just federal law, federal proceedings. The proceedings are the same. The terms for replies, the development of evidence is all regulated and guided by the same federal statutes. Very little
So I
nuances between
remember
courts.
learning, maybe it was from you, that certain states, like the state of where Rio is located, is more patent friendly, and the state where Sao Paulo is located is less patent friendly. Is that still the case? And if so, how does that?
No, I think we can say that nowadays both are patent friendly courts.
Oh, interesting.
Both and this I think is a positive testament to the efforts of specializing the trial judges and the appellate judges uh, by taking patent litigation and some other matters out of uh, the the entire group of judges and concentrating in a small group with as the years go by, we can witness the development of the arguments, the development and the courts becoming more sophisticated. So nowadays, both Sao Paulo and Rio, we could say, are the most patent friendly court. At the same time, the two court systems that have the largest experience, the largest number of cases, and the only two states that have specialized IP courts for patent trials. São Paulo has specialized panels for appeals. The Rio de Janeiro court system is working on putting together specialized appellate judges in this term. We hope that they will implement that and get the good results that the São Paulo state is enjoying.
Got it. Got it. And so one of the things, I think we can go back to the without we don't need this slide anymore. I think one of the things that I remember back when I was overseeing patent litigation, not just with you, but before that in Brazil, um, was how long it took, and has and not quite as long to solve a case as it took to get a patent, but comparably long. Has that changed? And if so, how so? And if it hasn't changed, are there different ways around that delay process?
Yes and no. It has changed to the point. of having preliminary injunctions being issued just a couple of days after we filed the request.
Right.
Um, in light of a jurisprudence of case law establishing what a PI request should have. So um, we all get more sophisticated and the court system more predictable as we have more cases. So
Right.
we follow what the courts decide. We understand what the judges want to see. We comply with that, and we are able to obtain the fast results. On the other hand, the Brazilian legal system allows for several ways of appealing from different substantive decisions and from several administrative decisions of case management throughout the trial and the development of the case. Usually, in a normal case, it will never ever happen that a plaintiff or a defendant will try to use every single means of appeal possible or allowed under the legal system. What we witness is that in patent cases, this is the rule. All those obscure type of interlocutory appeals of the interlocutory appeal out of the dissenting vote, something that you only read about on books at school, it gets filed on patent litigation because the stakes are very high. And why is that? First of all, Brazil has a strong preliminary injunction system and a strong um, permanent injunction system. And if you get the permanent injunction, you have to get out of the market. It's not only about damages, but at one point in time, it's about contempt of court. And Brazilian judges don't like when their orders are not complied with. Second, uh, because of the well-developed practice of preliminary injunctions and having those preliminary injunctions requiring um, likelihood of prevailing, it's not a matter of law. Just because you filed a patent
Right.
infringement case, you automatically get a preliminary injunction. You have to convince the judge that you will prevail at the end. That is a good balance of hardship, and that there is enough evidence to issue the preliminary injunction. What happens in Brazil is that what you would you expect in other jurisdictions to happen in few years, it all happens in very few months because of the decision granting a preliminary injunction. So, defendant will litigate claim construction. Defendant will litigate the theory of infringement to try to show the judge and ask the judge to vacate the injunction just granted, or to file an interlocutory appeal and convince the appellate court to vacate the injunction granted by the trial judge. So you can expect in Brazil that the battle for the PIs nowadays, oh, they happen much faster than ITC litigation.
Yeah. No,
I
that is my.
I wish I had the time that most, not all, uh, most of the ITC cases get, because sometimes it's a matter of days.
Wow. Well, I do remember that, and like ITC cases, uh, in my experience, you want to be prepared as much as possible beforehand. And I remember I always used to jokingly call it when I would refer people to your firm the licks or the Otto method of being hyper prepared. But is other than just making sure you have a very good brief, maybe you can speak about a little bit, sort of without giving any trade secrets, how you prepare your clients for the wild roller coaster of Brazilian litigation in this style.
Oh, um, um, clients usually ask how long it's going to take, how hard it's going to be, and how much it's going to cost. And I usually say we have to ask the defendant because it's all about what the defendant is going to do. Uh, but taking into consideration that we start a case with a preliminary injunction 8 out of 10 times, the defendants will be in always trying to catch up.
Right.
So we, as you know, we prepare to file the case and request a preliminary injunction for months in advance.
I remember our stack was this high of papers.
Yes. We don't have that no more. Now it's 100% electronic. But yes, that still, if you want to print it out, it's going to be that tall or even higher. So litigation in Brazil, due to the fact that most clients seek a preliminary injunction, starts with a brief that is highly substantial. You cannot request a preliminary injunction without showing that you have a good and valid patent, offering claim construction, and offering a solid theory of infringement. So that initial filing, it's very substantial and opens up to the defendant that it 8 out of 10 times is already suffering DPI to try to work at the same time every single issue that we had months in advance to work. So at
Right.
one point in time, we have to answer, we have to rebut the defendant's answer to claim construction, to the infringing theory, to every single piece of evidence we had prepared and developed, because that's the attempt to try to vacate or overrule the preliminary injunction granted.
And for our listeners out there, it's not just Otto's brilliant team coming up with great strategies. At least in my recollection, it's a lot of expert testimony in written form as well.
Yes. Expert testimony in Brazil goes a long way. Judges, just like the lawyers, don't have a technical background, did the law degree as an undergrad program, and have a group of technical staff at the court that assist them. Some of them are full-time employees at the court system. Some of them are appointed, just like the federal rules of civil proceeding in the US allow courts to appoint an unbiased expert or
Right.
an unbiased patent master, sometimes an administrative judge to decide some issues that the judge will not take. We have that system too. And the proceeding in Brazil, different from the US, it's very much paper-based. So experts don't get deposed, don't get cross-examined. There is no hot tubbing. All the experts do, it's write an opinion, and due process is achieved, allowing the other side to look into the opinion and file their opinions as well. And the judge will find a way to pick and choose, sometimes ask questions, and sometimes we have to file additional opinions to answer questions from the other side, questions from the court, and that's how the judge builds up the information to decide the case. So yes,
A lot of
it is
preparation.
important. It is important to prepare, and as you know, sometimes our schedule get impacted by the schedule of the experts, because we might be ready to file, but the experts are grading exams, or they have this huge presentation in an important event at another university abroad, and we have to wait for them.
Yes.
So we usually work since day one in establishing the experts with the clients and making sure that they secure time and the work is done with them, writing time to get our filing.
And I, at least in my experience, but I imagine this is general, that the greater the amount of preparation and the more sophisticated and robust the expert reports and the thinking, the easier it is to maintain the position achieved as in the preliminary injunction, the first grant of preliminary injunction, all through the process.
Yes, it is. Yeah, it is. Yes, it is. However, the Brazilian legal system allows and understands that you the Brazilian legal system doesn't expect you to do for the preliminary injunction everything that the system will allow you to do when proving your case on the merits during trial. So you will have a, an extra bullet, and this extra bullet is not only for plaintiff patent owner but for the defendant as well.
Right.
Well, but um, it is very rare that we see a major departure um, from claim construction and the infringing theory that we offer, and it's extremely hard to find a situation where we cannot basically use everything we developed for the preliminary injunction during the trial.
So it sounds like Brazil is a very important jurisdiction for people to keep in mind, and if they're prepared, they can make a lot of headway there. How we all know, and you know very well because I always see you at these conferences all around the world, that patent assertion, patent monetization, and patents in general have become very global. And how has sort of the globalization of both patents but the patent wars impacted Brazil, and what should people who are involved in patents know about how it's been impacted?
Well, um, Brazil gets um, its share of everything that goes on. So um, every now and then we get an anti-suit injunction coming from abroad. And why is that? We usually get a preliminary injunction 6 months before you get a case management meeting. So basically, when your case starts in the US, the case in Brazil is done.
Right.
Um, so defendants get nervous, and in the US, we have worked in four different anti-suit injunctions. The first one coming from California, uh, about 13 years ago. And in all those cases, we were able to put together information that we shared with the lawyers in the US. And every single of those anti-suit injunctions were reviewed by the district judges that had issued them
Hmm.
and vacated the injunctions. And one thing I can share with you, Dave, is that after we tell this to the Brazilian judge, the Brazilian judge is never very happy with that type of attitude from the defendant side in another jurisdiction trying to take the case away from the Brazilian judge. So we usually see that as payback time.
So does it make sense? I mean, Brazil is a wonderful country, and it's fun to visit. But does it make sense if there's someone who's a foreign stakeholder in the IP space to get involved on the ground, or
Oh, yes. Yes. Uh, the um, the Brazilian legal system in any trial, regardless if it's a patent case or not, it's very much paper based. So usually, the everyday, it's basically done by lawyers and judges and clerks. Um, it might be a series of short hearings. It might be a more substantial hearing. But when the party shows up, and when the party shows up coming from abroad, coming from outside of Brazil, that that has a very positive impact. It shows a deference to the Brazilian legal system. It shows a deference and the importance that the Brazilian decision will have for this patent owner from abroad. So it's always positive when we have people willing to participate.
And you get to have great food as well. So, how have the various disruptions, if at all, in life, you know, just to name a few, COVID, the trade wars, the Ukraine, all this other stuff, how has it, the Zoom work revolution, how has that impacted your practice in a meaningful way, if at all?
Well,
And how would you recommend clients or potential clients sort of address that as it relates to Brazil?
well, what we have in the beginning, um, there was a lot of uncertainty. We were one of the first um, Brazilian firms to be 100% at home, and that was on the week that the pandemic was declared. Uh, um, and we have established uh, for people at home um, the setups with the VPNs, with the two monitors, and with the uh, office chairs from the beginning.
Right.
As the time went by, last year we hired the most well-known Brazilian hospital, the Albert Einstein Hospital, to do a consulting for us, and we are the first law firm ever to obtain a seal of approval of a safe environment to have people coming back to the office, which we
Oh,
did
wow.
3 weeks ago. We have made a lot of investment. We have filters for the air that you find in the hospitals that treat COVID patients. Um, we have purchased a substantial number of those. We have updated our AC system to include um, hydrogen peroxide sprays and the pink lights. I forgot the name.
The ultraviolet light.
Ultraviolet.
Yeah.
Ultraviolet. Thank you. Uh, and we also got the Brazilian Association of Industries in Rio that also has accreditation program to come and validate everything that the hospital did in light of the Brazilian legislation, labor laws, safety rules, and with that, we started to have people returning. To this date, every day, you have to answer a questionnaire that comes in your phone. If one of the questions is a question that might raise the risk profile, you're suggested to stay home. If you try to get in the office, the door won't open because the system is connected to all the doors. Uh, and we monitor and follow everybody. I'm happy to say that we went through with a little over 300 people without major impacts to our members.
That's wonderful. That's really
Uh,
wonderful.
and in the court system realized it was also in the beginning a period of uncertainty, but few months later, the Brazilian court system realized that they needed to step up for the very needs associated with the pandemic, ruling on vaccine distribution, ruling on purchasing products for off-label use. Our life science group was very busy in
Right.
this last 2 years.
Sure.
And with that, the judges incorporated WebEx, Teams, and Zoom, depending on the court, depending which system each court has decided to use. Nowadays, um, with the situation of the pandemic being much easier, the rules allowing people to get together again and allowing people to get together without the need of using masks. Um, Several judges have, and appellate judges have returned to a 100%
In person.
uh, in-person workload. Some of the judges, the clerks, will ask the lawyers and say, listen, if you don't see a special reason, we can have, several of the hearings on Zoom, and several courts will allow an attorney from out of state, out of town, uh, to do the oral hearings with the Zoom or the Teams or the WebEx, not having to get someone to travel to do that in person at the court. So what we see is that the use of the video conferences systems have, they will be here forever.
Right.
They will stay, and it's up to court uh, rules, up to the particular judge. Some judges like more than others. Some judges don't like it at all. But in general terms, we see a lot of use. As of today, one of my partners is waiting um, to have a hearing in a court that is out of state in a matter of case management, and she is doing that out of her office.
Oh, wonderful.
So we do this on a regular basis now.
Wonderful. So, Otto, I thank you very much for all of your time. You've been very generous, as always. And so, what do you have a one or two takeaways that you want to leave our audience with about why Brazil and why IP in Brazil?
Well, two takeaways. First of all, every user of the of the global patent system knows that it takes forever to obtain a patent in Brazil.
Right.
This situation has severely changed in the last 2 years. Brazil is now issuing patents that had an examination request about 2.5 years ago or 5 years ago. So it's not like that forever wait that we had in the past. With PPH and several fast track proceedings, we can get a patent expedite, and I think our record is 44 days
Wow.
for a pharma patent, by the way, not tech, pharma. Um, so, looking into Brazil to obtain, to add the country in an adjudication campaign, um, has to take into consideration that you can get the patent much faster now. And second, depending on the product, depending on the method, depending on the service, Brazil will be a huge market. And obtaining a preliminary injunction here will assist the global settlement um, of several disputes.
With
We
with Go ahead.
we hardly ever get to damages in Brazil, because basically every single case we have, parties settle globally sometime after the preliminary injunction is granted.
With the large, that's really great, Otto. With regards to the large internal Brazilian litigation, has that created or spurred the creation of a investment market that likes to invest in IP litigation, or has that not come to Brazil yet?
Yes, Brazil is in the radar of all large uh, groups financing litigation, as in all large groups supporting or purchasing companies or patents for monetization. And we work for several of them, by the way.
I'm sure you do. I'm sure you. I think I may have recommended you to a few of them. Um, but speaking of recommending, Otto, I highly do. But how should our listeners get in touch with you if they want to learn more?
Well, um, we have our website. We have, it's easy to get in touch with us. We have all our communications ISO 27K compliant. And of course, if they get someone needs to get a hold of me over the weekend, they can always call you, because you know how to get a hold of me during the weekend.
Excellent. Well, I just hope the Imperial March doesn't show up when I call you. You know what I'm talking
Yeah,
about.
yes,
Uh,
I do. Yes, I do.
anyway, listen, Otto, thank you so much. It's been a pleasure to have you as a guest, and wish you all the best of luck, and hopefully we'll get to see each other very soon.
Pleasure talking to you, Dave. I hope to get together with you as soon as um, this traveling around the world permits.
Excellent.